Obstetricians are medical specialists responsible for dealing with pregnancy, childbirth, and the postpartum period. Since the relationship between medical practitioner and patients is a recognized category of duty, obstetricians have a single comprehensive duty covering all the ways in which they are called upon to exercise their skill and judgment. A claim for medical liability will only be valid once a breach of this duty is established. However, it is important to note that it is extremely difficult to prove breach of duty in obstetrician-related cases. There must be direct causation between the obstetrician's negligence and the injury sustained by the patient. Courts have found this causation difficult to prove as there is already a known high level of risk involved in obstetrics. Consequently, it is challenging to attribute the injuries of the patient to the negligence of the doctor alone. The current medical negligence liability system has two key purposes, including providing compensation to patients who have suffered a negligent medical injury and penalizing doctors and specialists whose negligence has caused injury. Daniel Kessler performed extensive research in this area, and his findings provide evidence suggesting that the current system achieves neither outcome. In most cases involving obstetrician negligence, where the plaintiff is successful, such as Hill in the state of Queensland, the payout is quite a large sum involving millions of dollars. This growing cost of negligence payouts has many negative effects on specialists within the profession. Insurance premiums have risen dramatically within the last 10 years, and obstetricians are bearing the cost of this increase. An insurer from United Medical Protection highlights that these costs are due to the high risk involved in obstetrics, and consequently the long-term injuries that may result from negligence. A recent interview published by the Australian Medical Association involving the Secretary of the National Association of Specialist Obstetricians and Gynecologists shows that between 1991 and 2001, insurance for obstetricians has risen from $6,000 to over $80,000. McLeod depicts that although a doctor is rarely at fault completely, the lifelong injuries that may be sustained during a negligent childbirth are the reason for these increases. A major concern of the rising insurance premiums and lengthy litigation processes involved in obstetrics is the subsequent damaging effect it has on the profession. A speech by Palmisano in 2005 states that providers argue that the liability environment is not just a professional problem for doctors and hospitals, but also a grave public health problem because liability costs drive physician specialists to leave practice or stop providing high-risk services. This indicates that future individuals looking to pursue a career in this area may be deterred by the damaging litigation and the fear of involving themselves in these high-risk services. A decrease in individuals who want to practice obstetrics would greatly impact society as a whole. Another issue that may also be a result of the current legal system involving obstetrician liability is the idea of defensive medicine. Doctors may be focusing on avoiding potential litigation, and this may in turn affect their standard of work. Defensive medicine occurs when doctors order tests, procedures, or visits, primarily to reduce their exposure to malpractice liability. This has clear damaging effects on the public health system in general, and further reforms aim to rectify this issue. There are several policy matters involving the state of the law regarding obstetrician liability. Some of these negative effects are serious public health concerns, and further reforms aim to protect the interests of obstetricians to reduce negative outcomes. On the other hand, the public and lawyers alike desire for patients to be compensated completely for injuries caused by negligence. Individuals affected by medical malpractice may suffer severe lifelong injuries, and it is only fair that compensation completely covers all of these costs. Further reforms aim to address these policy matters and strike a balance between the profession, the interests of obstetricians, and the injured party.